One of the biggest concerns about coming forward to the university with a disclosure of sexual or gender-based violence, or SGBV, is how that information is going to be used, shared, and protected. The University of Alberta is subject to the Alberta Freedom of Information and Protection of Privacy Act, or FOIP, which regulates how we collect, use, share, and protect personal information. In general, the university is only permitted to disclose personal information for the purpose for which it was collected. For example, if I were to put on a workshop and I collected names and emails of the participants in order to provide them with a certificate of attendance, send workshop materials in advance, and so on, I could not disclose that list of names and emails to someone else who maybe wanted to contact them to promote a new business on campus, unless I had their permission to do so. Individuals can request records that are in the care and custody of the university, which contain personal or general information. The Information and Privacy Office provides or declines to provide that information as guided by the FOIP Act. Any use or sharing of information around disclosures of SGBV must be FOIP compliant. Privacy and the protection of personal information is essential for creating an environment where disclosures feel safe in disclosing their experience and seeking support. When a person discloses an experience of SGBV to a university employee, they might be doing so to seek support or assistance, or to find out what options the university offers. When they choose a specific option, the university collects the information they need to provide it. Consider this. The information provided in a disclosure of SGBV is especially personal and sensitive, and disclosures can include personal information about a number of individuals, and there could be serious consequences for those involved if that information is shared or used inappropriately. Privacy is about protecting personal information that belongs to a person. Knowing how critical privacy and the protection of privacy is, the SGBV policy promises that the university will protect the privacy of those involved in a disclosure or complaint of SGBV as much as possible. In the FOIP Act, personal information means recorded information about an identifiable individual. For example, personal information includes things like a person's name, address, phone number, their race, ethnic origin or religious associations, age, sex, marital or family status, their fingerprints, information about their health, education, finances, employment or criminal history, opinions about the person, and the person's own views. FOIP also regulates how a public body like the university can use that information once we have collected it. According to FOIP, personal information can only be used for the purpose for which the information was collected or for a use consistent with that purpose, if the individual the information is about consents to another specified use, or as allowed in specific sections of the Act. You can already see that protecting a person's privacy doesn't mean that we lock down that information and keep it top secret. We will protect privacy to the extent possible, but there are limits. If, for example, there's a risk of harm to oneself or others, the university's obligation to provide a safe learning environment may outweigh the protection of personal information. In addition, some options for disclosures also require personal information to be shared. For example, if a disclosure chooses to make a complaint, procedural fairness requires that the person under allegation has a right to know at a minimum the discloser's name and the nature of the allegations. Other options, such as modifications or interim measures, also involve limited disclosure in order to administer them, including the name of the discloser sometimes. There may be times when information has to be disclosed as a matter of law, such as under the Alberta Health and Safety Act, or FOIP. In all cases where information is shared, it will be limited to only the information that is reasonably necessary and only shared with those who have a legitimate need to know. Every situation is different, and the extent to which the university can maintain privacy around a disclosure is determined on a case-by-case basis. Wherever possible, as a trauma-informed practice, We want to inform all parties of the limits on the university's ability to protect their personal information. While privacy is about the person, confidentiality is about individual university processes, and all of our processes are confidential. There is no public discussion about specific cases. No public record is generated. There's no disclosure of information learned within the process except in compliance with the various laws like FOIP or the Occupational Health and Safety Act. When university employees use or disclose personal information that they learn solely as a result of receiving a disclosure or administering or participating in a university process related to SGBV, they must do so in accordance with FOIP. Individuals, on the other hand, are not subject to FOIP, but it's still important for parties and witnesses to keep any personal information they learn solely through any university process confidential. In other words, if an individual learns of any personal information belonging to another person through a disclosure, complaint, investigation, interim measures, modifications, or any other university option, they should not post that information on social media or online, distribute any confidential university documents in whole or in part, share another person's personal information with individuals outside of their immediate circle of support, or prompt or urge others to disclose personal information belonging to someone else. That said, we have to make certain that our instructions on confidentiality don't look or feel like a gag order. People need support to process their experiences, and talking is key to healing. Research shows that people who talk about their traumatic experiences tend to move on more quickly and are less likely to develop PTSD. Any instructions we give to individuals about confidentiality should never prevent parties from seeking the help and support they need, and should acknowledge that it is perfectly appropriate for individuals to have a close circle of support. This can include friends, family, spiritual leaders, counselors, and so on, as defined by the individual. But we also have to make sure the parties clearly understand the expectations around privacy and confidentiality. From the sexual and gender-based violence policy, the university does not prohibit parties and witnesses from speaking about their own experiences. However, when disclosing another person's personal information within their immediate circle of support, the party or witness is also responsible for communicating the need to keep the information confidential. In general, it's important for disclosures to understand that making the information public, for example, in media, social media, or wider social groups, is not okay. But disclosing some information for a specific reason, for example, telling an instructor that you need extra time because you're involved in a GBV investigation, on a need-to-know basis and without identifying anyone else from the process, is fine. Parties should not share documents, but talking through details of their own experience with their circle of support is permitted. What they discuss within their circle of support may include the identity of the other party and the existence of or their experience in a university process, so long as they also caution their circle of support of the risks of disclosing the information any further or misusing that information in any way. Inappropriate disclosure of another person's personal information may breach their privacy rights. This brings about risks to the individual who improperly discloses personal information about someone else. For example, if a party divulges private information that they learned through a university process, they put themselves at risk of legal action by an individual who believes their privacy has been breached. Defamation and other civil suits have become more common in recent years. In some cases, inappropriate disclosure of information can compromise the integrity of an investigation to the extent that the investigation may end or result in a finding that there was no policy violation. For more information on privacy and confidentiality, the university's Information and Privacy Office is available to answer questions.